All right, let's go on ahead and talk about it. So the United States Supreme Court has just released their decision in the case of the United States of America versus Rahimi. Let's go on ahead and dive into it because this is an important case that talks about the courts upholding the disarming, if you will, of domestic violence, abusive individuals, where a court has found that there is evidence to substantiate that. I got questions about that. Let's dive into it. Here we go. All right, so here we go. Disclaimer, other videos and other things that we're going to use are authorized under Title 17, United States Code 107 for U.S. copyright law for fair use, criticism, all that great stuff. I am not a lawyer, and this is not legal advice. However, as a criminal justice lecturer and a scholar in this and a firearms instructor, all that stuff, you follow me, you already know what it is. So let's just go on ahead and dive into it because I can tell you, having been a person who has been subjected to such an order, I have questions, not about what the United States Supreme Court said, but about other factors that are concerning alleged or actual domestic violence abusers. Let's go on ahead and dive into it. So this is straight out of the Supreme Court of the United States. They just released this decision today. Let's go on ahead and dive into it and kind of put it on the big screen right there so you can read it. I'm going to read some of this stuff verbatim. So this is the United States versus Rahimi, certiorari to the United States Court of Appeals for the Fifth Circuit, argued November 7th, 2023, and decided June 21st, today, 2024. Respondent Zaki Rahimi was indicted under Title 18 United States Code Section 922 G8, a federal statute that prohibits individuals subject to a domestic violence restraining order from possessing a firearm. A prosecution under Section 922 G8 may proceed only if the restraining order meets certain statutory criteria. In particular, the order must either contain a finding that the defendant, quote, represents a credible threat to the physical safety of his intimate partner or his or her partner's child under Section 922 G8C1, or by terms of explicitly prohibiting the attempted use or threatened use of physical force against those individuals who are so protected under 922 G8C2. Rahimi concedes here that the restraining order against him satisfies the statutory criteria, but argues that on its face, Section 922 G8 violates the Second Amendment. The district court denied Rahimi's motion to dismiss the indictment on the Second Amendment grounds. While Rahimi's case was on appeal, the Supreme Court decided the New York State Rifle and Pistol Association Incorporated versus Bruin under 597 U.S. 1, 2022. And in light of Bruin, the Fifth Circuit reversed, concluding that the government had not shown that Section 922 G8, quote, fits within our nation's historical tradition of firearms regulation. Here's what the Supreme Court held, okay? And in part, I do agree. Held, when an individual has been found by a court to pose a credible threat to the physical safety of another, that individual may be temporarily disarmed consistent with the Second Amendment. Since the founding, the nation's firearms laws have included regulations to stop individuals who threaten physical harm to others from misusing firearms. As applied to the facts here, Section 922 G8 fits within this tradition. The right to keep and bear arms is among the fundamental rights necessary to keep our system of ordered liberty under McDonald v. Chicago. Hey, that's the case that assisted us in getting concealed carry. Yay. Here we go. That right, however, is not unlimited. District of Columbia v. Heller. Okay, y'all remember the Heller decision? Shouts out to Dick Heller. The reach of the Second Amendment is not limited only to those arms that were in existence at the founding under Heller. Rather, it, quote, extends prima facie to all instruments that constitute bearable arms, even those that were not yet in existence. So they're going to go on ahead and go over a whole bunch of stuff here, and I invite you to read that. The link will be in the comments section. Let's get to some of the other things that, here we go. Rahimi has been found by a court to pose a credible threat to the physical safety of others, and the government offers ample evidence that the Second Amendment permits such individuals to be disarmed. So you're more than welcome to go on ahead and go through that. But here's something I wanted to focus on too. Let's go to page 5 of this. Okay, let's go to page 5 of this. This is crazy, right? Now, Chief Justice Roberts delivers the opinion of the court. When you get to the historical context of this particular case, it is abhorrent. Okay, in December 2019, Rahimi met his girlfriend CM for lunch in a parking lot. CM is also the mother of Rahimi's young child, AR. Okay. During the meal, Rahimi and CM began arguing, and Rahimi became enraged. Brief of the United States 2. CM attempted to leave, but Rahimi grabbed her by the wrist, dragged her back to his car, and shoved her in, causing her to strike her head against the dashboard. When he realized that a bystander was watching the altercation, Rahimi paused to retrieve a gun under the passenger seat. CM took advantage of the opportunity to escape. Rahimi fired as she fled, although it is unclear whether he was aiming at CM or the witness. Rahimi later called CM and warned that he would shoot her if she reported the incident. Undeterred by this threat, CM went to the court to seek a restraining order. In the affidavit accompanying her application, CM recounted the parking lot incident as well as the other assaults. She also detailed how Rahimi's contact had endangered AR, their child. Although Rahimi had an opportunity to contest CM's testimony, he did not do so. And on February 5th, 2020, a state court in Tarrant County, Texas, issued a restraining order against him. That order, entered with the consent of both parties, included a finding that Rahimi had committed family violence. It also found that this violence was likely to occur again, and that Rahimi posed a credible threat to the physical safety of CM or AR. And based on these findings, the order prohibited Rahimi from threatening CM or her family for 2 years. That's what's called a plenary order of protection. It also suspended Rahimi's gun license for 2 years. If Rahimi was imprisoned or confined when the order was set to expire, the order would instead terminate either 1 or 2 years after his release, depending on the length of imprisonment. Here we go. In May, however, Rahimi violated the order by approaching CM's home at night. He also began contacting her through several social media accounts. In November, Rahimi threatened a different woman with a gun, resulting in a charge of aggravated assault with a deadly weapon. And while Rahimi was under arrest for that assault, the Texas police identified him as the suspect in a spate of at least 5 additional shootings. The first, which occurred in December 2020, arose from Rahimi's dealing in illegal drugs. After one of his customers, quote, started talking trash, end quote, Rahimi drove to the man's home and shot into it. Brief for the United States 3. While driving the next day, Rahimi collided with another car, exited his vehicle, and proceeded to shoot at the other car. 3 days later, he fired his gun in the air while driving through a residential neighborhood. A few weeks after that, Rahimi was speeding on a highway near Arlington, Texas, when a truck flashed his lights at him. Rahimi hit the brakes, and then the truck, and cut across traffic to chase after the truck. Once off the highway, he fired several times toward the truck and a nearby car before fleeing. 2 weeks after that, Rahimi and a friend were dining at a roadside burger restaurant. When the restaurant declined his friend's credit card, Rahimi pulled a gun and shot into the air. Police obtained a warrant to search Rahimi's residence. They discovered a pistol, a rifle, ammunition, and a copy of the doggone restraining order. Jesus Christ. I got to ask this question. Attorneys for the respondent, Rahimi, could you find a better candidate? There are plenty of people out there who have been falsely accused of domestic violence, where they've been subject to the challenge, the order of protection, and then to go, because this is how it works. During order of protection, and I would know firsthand, I would know firsthand. So during the order of protection hearing, it's an ex parte hearing. And what happens is the alleged or actual victim goes to domestic violence advocates, and they make whatever claim they're going to make. And then the domestic violence advocates are extremely skilled at crafting the language so that it fits the eyes of the courts, because sometimes people don't know how to explain these things before the court, right? And so they'll testify under oath, whatever they're going to testify to, and the judge will ask those questions. But the petition is as it is written, with crafty and cleverly worded language, right? And so it's an ex parte hearing. Ex parte is Latin for simply without the other party being present to respond. So provided there's enough information and the court believes that there's a credible threat of violence, and that is a subjective term depending upon the county where you're in. And I want to help you all understand this, that the courts are more geared towards giving women and children the benefit of the doubt. Men have to come to court with proof. Women and children are given the benefit of the doubt. Men have to come to court with proof. A man cannot go into the court and just outright make a claim of domestic violence without a lot of proof, because courts expect us to be able to take the abuse, right, in certain cases. Hey, it's subjective, okay? But they go in there and get that order. In Illinois, at least, I can't speak for other places, but in Illinois, by statute, 21 days, that order of protection expires, and it's the date for the plenary hearing. That order of protection expires, and it's the date for the plenary hearing. So what does that mean? At the plenary hearing, the plaintiff has to bring even more evidence to prove, right, clear and convincing, or even by preponderance of the evidence. See, the ex parte hearing to get the order, very low standard, but the plenary hearing is a higher standard. I would say that the ex parte hearing is a more likely than not, and then the plenary would be a preponderance of the evidence or clear and convincing evidence. It's a higher evidence. It's not probable cause for a criminal matter, and it's not proof beyond a reasonable doubt for a criminal conviction matter. That's the highest standard of evidence, right? And so, I mean, I would love to speak to the attorneys for Rahimi. Could you not have scoured, if that's the right word to use, could you not have searched the Second Amendment community to find a better candidate to use to argue a Second Amendment case on its face? You find the shittiest of them. This is the type of person who should have a restraining order against him, especially if there's proof that the government can show for the matters asserted by the victim in this matter and the victims in other matters. This is the type of person that the order of protection is designed for. Not a person like me, not a person like a bunch of people who I know, where they have shown me clear and convincing evidence that they were not assaulting or they were not at fault. And then they brought the evidence to the plenary hearing, and then the judge sees that this woman or this other person weaponized the sympathies or empathies of the courts against this man simply because she doesn't like him and knows that the system will be used against him in the beginning, where he may get justice in the end. There could have been so many other people that you could have picked. Why do you pick the one who definitely needs the order of protection? So I'm not surprised that this is an 8-1 decision to uphold temporarily restraining people like him. This is the case for why you should snatch this away. This isn't the case for, oh, let's give it to the Second Amendment folks and preserve gun rights. Using him, this is the shittiest of the shitties. Sound off in the comments. Go read the decision. You can read the decision. It's got some great stuff in there. But I agree with the Supreme Court. Like, didn't I say it? Systems are not just paper. They are people too. Systems are not just paper. They are people. This is the person you want to have a restraining order. But I'm going to tell you this, a restraining order is not enough. It is your job to protect yourself. But this is the person for whom the restraining order is designed for. A real person who should be restrained from owning firearms? Sign up in the comments. What do you think? This is Instructor Mike, and you've been trained. I'll catch you on the next one. Here we go. Let's go. Let's go. Let's go.